Welcome back to Supreme Myths. I'm excited today to have as my guest Professor Jake Charles of Pepperdine Law School. He is the former and inaugural, I believe, executive director of the Duke Firearms Center. He's a graduate of UC Irvine and Duke Law School. He has a master's degree. He clerked on the district court. He clerked on the Court of Appeals. He worked for O'Melveny and Myers and numerous other places, but that's not why he's here. He's here because a couple years ago, he wrote an article on Bruen, and I believe you were still at Duke at the time, that was outstanding and amazing. It's in the Duke Law Journal, and I really noticed it. And then I got to know Jake and realized this is a outstanding young law professor. So he was on a year ago, and now he's back again, joining Mike Dorf and Jack Balkin as the only people on this podcast who've been repeat guests. That company should tell you what I think of Professor Charles. Jake, thank you for coming.
Thanks for having me, Eric. It is so delightful, and thanks for those kind words.
Well, you deserve them. Okay, so we were hoping that we would get the Rahimi case this morning. For the non-lawyers listening, the Rahimi case is the last big gun case of the term. It is huge. We're all waiting for it. So, Jake, why don't you, and we'll get to the bump stocks case from last week after this. But first, why is Rahimi so important? What's the context? What happened? And I guess I'm going to ask you for a prediction.
Okay. I think actually a prediction in this case is probably easier than a prediction in a lot of other high-profile, contentious, politically inflected cases to the court. I think most people watching the case, and I do certainly think the court is going to uphold this law. And the biggest question is what the reasoning is going to look like. So let me back up then and say why this case is important. So it's extremely important because, as you said in Bruen a couple of years ago, the Supreme Court said, look, in reviewing Second Amendment challenges, what courts have to do now is not apply any form of strict or intermediate scrutiny, not do what they do in run-of-the-mill First Amendment cases or equal protection cases. Instead, what they have to do is test only whether the regulation today that's being challenged is, quote, consistent with this nation's historical tradition of firearms regulation. And what that means, as the court said, and as lower courts have interpreted, is that the government has to come forward with some regulations or set of regulations to show that the law now fits with what we did in the past, how we regulated guns in the past. And the law at issue in Rahimi is federal law called 18 U.S.C. 922 G8 that bars people who are subject to domestic violence restraining orders from having guns during the time that that restraining order is in effect. And the Fifth Circuit got this case and said, you know what? We don't see anything in the past that looks like a law that would take away a domestic abuser's guns. And so you can't do that today. And the Fifth Circuit's decision, I think, was pretty shocking. This case hadn't received a lot of attention before the Fifth Circuit got it. It was on appeal of a criminal conviction. It wasn't a civil challenge brought by an advocacy organization like a lot of the previous cases were. So it was a surprising decision. And it was surprising also because this domestic violence issue was one of the very issues that many of us who were concerned about what a historical test would do prior to Bruen had brought up as this test case of, well, what do you do with domestic violence? It's certainly a social issue that we view much more differently today than we viewed at the founding. They didn't have a problem of domestic violence with firearms in the founding generation. So, of course, they didn't regulate, leaving aside all the other issues about why they might not
Jake, are you sorry to interrupt? Are you saying there weren't a lot of husbands using muskets to shoot their wives?
There was not a lot of firearms violence in intimate partner relationships, as if you can imagine that.
Good to know.
Yes, and so yeah, so the technology, right, is completely different. The social attitudes are completely different. The place of women in society is completely different than it was at the founding, and yet none of that really mattered to the Fifth Circuit. And so the Supreme Court took this case to maybe say something clarifying about Bruen and how to do this historical test, but I think almost certainly to reverse the Fifth Circuit. So what's at stake is the future of governmental authority to regulate firearms, and particularly firearms in the hands of dangerous people, but also kind of more directly kind of the fate and lives of millions of women across America who are threatened with firearms by intimate partners today in the way that they weren't, as you said, in the 18th century.
So it's not your area what I'm about to ask you, but I'm sure you've been reading about this. So Clark Nelly of Cato, I believe, or used to be a Cato. I think he's a Cato. Clark is a frequent guest of mine at various things. We disagree on everything, but we're friends, and he's a great guy. Clark's argument about this case is nuanced. It's not, he's not a law professor, but he's very academic. I mean, he can be very academic. And Clark says, in theory, and he's a very strong proponent of gun rights, in theory, no, if someone has a history of domestic abuse, they should not be armed. I think he would say that, probably. But he says we have a national problem with these, and this is what Judge Ho said on the Fifth Circuit, and I believe a concurring opinion, don't hold me to that, but I think it was in a concurring opinion, that these domestic relations protective orders are always given out willy-nilly. What judge is not going to issue one in today's world if a woman says, I feel in danger from my husband? Well, they're going to get a protective order according to Clark. And this next step, of course, I don't agree with, but he does, and that's fine. We don't let people forfeit constitutional rights that easily. Because nonviolent people get slapped with protective orders routinely, according to Clark, then the court needs to figure out a way to change that. And if they change that, then he's okay with this law, I think. But in the absence of that, he's not okay. That's the strongest argument I've heard for. I don't believe it, but it's the strongest argument I've heard. What do you make of all that?
Yeah. So a couple of thoughts. I think one, first of all, it's not my area. The logistics of domestic violence restraining orders in general. I think what the Solicitor General said during the oral argument is that it sort of flies in the face of the presumption of regularity to have a constitutional rule that implies that trial court judges are not issuing orders that are justified by the law and the facts. Unless there is evidence that this is happening in areas where in a number of instances where it's completely not justified, then I think we believe that lower court judges are applying the law the way the law says, which is in this particular law, the federal prohibition only applies if the order itself made a determination that the person is a credible threat of danger to an intimate partner or a household member, or that specifically prohibits them from, I think, making threatening gestures or something like that.
Sure. Yeah.
And so in this case, the trial court did make that finding, and I think that's one of the things that's sort of lost sight of in this case is that if you have concerns about the operation of this statute to other classes of cases, those are challenges to bring up in those cases. The orders themselves can be challenged in state court. The order's constitutionality can be challenged on an as-applied basis in federal court or in a federal prosecution. But in this case, there was an actual finding made that he's a credible threat, in fact, he was, right. I mean, he made threats before. Yeah, and he fired his gun on apparently 5 different occasions, or allegedly on 5 different occasions. So I think to the extent that there are those concerns, and I share your view that they're not really borne out by what the evidence that I've seen looks like of when these orders are being issued and the number of them that are being denied, which, the fact that there are a large number of them being denied shows they're not being automatically granted. But if there are those kind of issues, then those are not to be brought up on a facial challenge. And the Fifth Circuit invalidated the law facially, which even Justice Gorsuch, I think, during argument was like, how is it certainly all the issues you're bringing up here about due process, about temporary possession, like all those things are not issues for us to deal with on a facial challenge. So that's sort of my view on that.
So I want to get wonky for a second. So I have a wonky alert for the audience, okay? Just for like 2 minutes. We'll get back to being non-wonky in 2 minutes, I promise, 3 minutes. What's fascinating about what you just said, Jake, and I hadn't thought of it before. So if this were a First Amendment case, okay? Gun advocates love to compare the First and Second Amendments. I think it's the stupidest analogy in the history of time, since every democracy has free speech and a lot of democracies don't have gun rights. But leaving that aside, if this were a First Amendment case, there would be conservative justices and maybe some liberal ones saying, but you are clearly covered by this law. Like you personally are clearly covered because this guy made threats. It's in the record. It's documented. So what you're saying is this law applies, I'm trying to do this in a way that for non-lawyers. What you're saying is other people out there are having their rights violated. And we call that overbreath. in the context of the First Amendment. It's a real thing in First Amendment law, but it's disfavored, especially by the conservatives. Where you can only challenge a law as applied to you most of the time. So here's the amazing thing. This is a facial challenge. Theoretically, don't they have to show that there are no legitimate applications of this law? And if the court were going to take that seriously, I think the most ardent Second Amendment rights person in the galaxy would say, if someone has had a protective order slapped on them after proven cases of domestic abuse that's in the record, of course they can be de-armed. I think everybody would say that. The court is going to just slide over this, I think. And doesn't that make you sad? Because if they were honest, they'd have to deal with that question. Are they going to deal with that question?
I don't know. It's possible that Justice Gorsuch, it's possible that maybe a few justices say something about it. Or maybe there's like a statement that, well, obviously has to lose here because he was subject to an order that was issued after appropriate process and he was subject to this findings. It's possible they do something like that. But I completely agree. And I think this is one of the big questions going forward in Second Amendment litigation is going to be whether or not these facial challenges get some kind of, whether there's some kind of Second Amendment overbreadth doctrine. In other words, whether there's some kind of way in which an individual can challenge a gun law on the grounds that it just sweeps too broadly. And even if it might be applicable to my conduct, it's just too broad of a law to be in place at all. Justice Gorsuch's comments, and he's someone I think who might have otherwise been sympathetic to an overbreadth doctrine. His comments during oral argument were clearly under the standard the court has set in general, the Salerno standard, which is the no set of circumstances in order to show that a statute is unconstitutional on its face. There are no set of circumstances in which it can be constitutionally applied. He invoked that in this context, which suggests to me that he thinks there's no kind of special rule for Second Amendment cases. And if that's the case, I just don't see how Rahimi could possibly win. The Fifth Circuit did not address this in saying why the statute is facially invalid, even if there might, even the narrowest reasoning under strong gun rights proponents is that there's a history of disarming dangerous people. And so I think even on the narrowest justification that Rahimi loses, if we're looking at his conduct and the order that applies to him.
Two kind of op-ed responses to that. One is Judge Ho, who made a big deal of this argument about the system of domestic relations protective orders in this country. Yeah. I am very confident that, like you and me, Judge Ho knows very little about domestic relations law, because that's not anything federal judges do. My federal judge I clerked for said, I don't care if there's diversity jurisdiction and $20 million at stake. Do not bring me a domestic relations case. Get rid of it. Find an abstention doctrine. All federal judges feel that way, or most of them do. So I want to say that. And the second thing that's Judge Ho, but the second thing I want to say is the idea that in 2024 America, with 420 million American guns, and guns in Americans' hands, and gun violence left, right, and center. Jake, a place I have lunch once a week was shot up last week, 5 people injured, 2 blocks from my law school. Thank God, no one was killed. Thank God. But there was violence, gun violence. My kids have had to have what do you call it? They were sent to the basement twice this year because of guns close to the school. The idea that the Supreme Court would make it easier to get guns, easier to challenge laws, harder to make it harder for criminals to get all that stuff. It's just unbelievable. I mean, it's just, I don't, do you find it unbelievable? I find it unbelievable.
Yeah, I do. I think particularly when you look at Bruen definitely made it harder for government to regulate. And when you look at, I think one of the things that's really hard for me to get my mind around is when you read Bruen, it doesn't really give a good justification for imposing this history and tradition test. It says nothing about there's something unique about the Second Amendment that demands this sort of test. It doesn't justify why the founding generation would have thought that only those laws they'd already enacted would be somehow the scope of what the government could in the future ever do to regulate firearms. So it doesn't say anything kind of normatively about this vision of of applying a history and tradition test to the Second Amendment. And I think particularly when you look at the distance between the way that firearm harms operated in the founding era and the way that firearm harms operate today, there just really was not much firearm violence in the founding era. There was a lot of interpersonal violence. Most of it was not connected to firearms. And so the reason that we had few firearm regulation at the founding was that it wasn't a social problem they dealt with. And so even if you're an originalist, I think to understand what they would have thought the government could do to regulate firearms requires looking at what they were trying to deal with at the time and what they were trying to guard against, and then projecting that forward to the facts on the ground today, which are much different than the facts on the ground that they were dealing with. So yes, I share your extreme concern about the Supreme Court announcing a test that makes it much harder to regulate firearms.
A test that, as you and I discussed last May, a year ago, a test that is inconsistent with any reasonable originalist interpretation of how to do judicial review.
Yes.
I just want to also, you know much more about this than I do. My understanding is, though, Boston, Philadelphia, New York City, they had gun laws. You couldn't take muskets into pubs, and right? Am I wrong about that?
Yes. So there certainly were gun laws in the founding era. A lot of them were about the kinds of gun harms that you had, like firearms or like gunpowder storage, right? So gunpowder, they don't want to explode, and so they regulated in a way that was really burdensome on people who wanted to exercise what we would today call gun rights. So yeah, there were certainly regulations, and as guns proliferated, as revolvers and handguns became more concealable, we saw more regulations. And this is kind of the history of gun regulation in the United States, is that as technologies and social changes occurred and guns became a problem, or certain types or ways of carrying guns became a problem, we see the regulations cropping up to follow that and to address those concerns. And we don't see lots of regulations around things that weren't a concern in the founding era. So we don't see prohibitions on particular people possessing firearms like domestic abusers in the founding era, because domestic abuse with firearms was not a problem in the founding era. Right. We see the regulations following the social problems that they were meant to address.
Two last questions about Rahimi, and then we'll go on to the case that was actually decided last week on guns. Although I actually don't think it was a gun case. I think it was an administrative law case. But leaving that aside, two last questions. I think I agree with you that, of course, the court didn't take this case to affirm it, probably. So here's my prediction question. Not what the court's going to do. What are Thomas and Alito going to do?
Yeah. I think they are the wild cards in my mind. I find Justice Thomas sort of hard to read during oral arguments. In the Bruen oral arguments,
he's easy. Jake, he's easier now because he talks.
Yes.
For most of my career, you couldn't read him. We started the same year.
Yeah, when he said nothing.
Yes,
that would be harder for sure.
Yes,
but in the Bruen arguments, he was asking about the differences between urban and rural gun regulation, which does have deep roots in U.S. history. And in his opinion that he wrote, has zero differential regard for rural versus urban. So I had thought, based on Bruen, maybe he'll say something about that. So Rahimi, I'm not quite sure. I think he was a little bit skeptical of, echoing some of Judge Ho's concerns. Alito, I think, is always skeptical of the government when it comes to guns. Or anything that he doesn't like. So I think he's naturally skeptical. On the other hand, like Alito, I think we talked about this last time too. Like Alito doesn't like, criminals either. So
right.
I'm sure that he would say something like, of course, Zaki Rahimi shouldn't have guns. Maybe he'll say that means the government should have convicted him faster, or should have held him, pre-trial. Like maybe he'll say something about that. But I don't know. I don't know. I don't have a good guess.
And I have a last question, and I'm sorry, this one was not in our tentative roadmap that I sent you, but I have to ask you.
Okay.
It's interesting. You have been a tenure track law professor. This is starting your third year in the fall. And then how long were you at Duke before that?
3.5 years.
Firearms? Okay. And I know you have at least mild, if not moderate, you can describe it how you want, realist sense about you. I don't know exactly where the contours of that are, which leads me to my question. If the court were to just adopt the Fifth Circuit's reasoning, like almost, just basically write its own opinion, but basically do what the Fifth Circuit did, which you and I both agree would be unbelievably inconsistent with text, history, tradition, and other than Bruen, precedent. Will that is there would that change your view on the Supreme Court? Like, is it so bad that wherever you are now, it would? And I'm not asking you that question. Would it take you to another level of discouragement? Shelby County did that to me. To me, Shelby County and the idea that the Civil War amendments, Congress's power under the Civil War amendments, would be limited by an equal state sovereignty principle, which is inconsistent with every single thing we know about the 13th, 14th, and 15th Amendments. That pushed me. I wrote my book 3 years before that about the court not being a court. But that case put me over the brink.
Yeah.
Would this case put you over the brink?
I think I probably would feel, similar to how you're saying that you would feel about the Shelby County case, in the sense that I think Bruen was not a well-reasoned decision at all, and is
you've made that clear very well. In fact, better than anybody. Better than anybody.
But yes, I think this would be it certainly would be a step further for me on discouragement about the court doing law-like things. I mean, I don't know how far I am already on that. But yeah, it would be more discouraging if the court was to say, like, even this is not enough to get them to rethink what they're doing with this test.
Right. Okay. I don't think that's going to happen, but we'll find out. Okay. Yeah. So last week, we had this bump stock case. Yeah. I don't want to spend too much time on this, but give us the context, the holding, and why you think it's important.
Yeah, so the bump stock case, as you said, it's not a Second Amendment case, but it is a firearms law case because it concerns the government's ability to regulate firearms or firearms accessories. So this was a bump stock is a device that you can attach to a rifle that replaces the standard stock and essentially enables a standard rifle, a semi-automatic rifle, to fire at a rate that mimics the rate of a machine gun or automatic fire, which is about 8 to 10 times faster than a person can normally fire a semi-automatic firearm. And what happened was in 2017, I believe, after the Las Vegas shooting, where the shooter used a bump stock to kill the most people in any mass shooting in U.S. history, there was a public outcry that, what are we doing with these kind of accessories that can enable a firearm to shoot in the same way that a machine gun shoots? If we don't allow civilians to have machine guns for the most part, then why would we let them have this device that can enable them to do the same thing? And so there was debate in Congress. Congress ended up not doing anything, but the Trump administration through ATF, which is authorized under the statute, the Gun Control Act of 1968, to enact regulations that implement the definition of a firearm or of a machine gun. It went back and looked at the way these bump stock devices were used and issued a regulation that said, yes, these bump stocks actually do convert a semi-automatic rifle into a machine gun, which under federal law is defined as a firearm that can, with a single function of the trigger, fire more than one bullet automatically. And ATF looked at that and said, yeah, that qualifies as a machine gun. And so therefore it's subject to all the registration, taxation, and other prohibitions that machine guns are subject to.
Can I pause you for 1 second, Jeff?
Yes.
I want to pause you for 1 second. That's a great background, but I want to pause on one point. The Trump administration did this after previous Democrat administrations did. Democratic did not.
Yes.
Right? They considered it but didn't. And the point I want to make about that, there's 2 points. One is the Fox News' call that Obama was going to come take your guns. Not only was that false in every way, but it turned out, I believe, the Trump administration probably did more gun control than the Obama administration did. Yes. And that's probably a political decision made by Democrats not to do unpopular things So I just want to say that whole disaster of a storyline is crazy. And then it comes back to haunt Democrats because one of the arguments is, well, the ATF, had this position for this long. Why did they change their minds? Yeah. Now, here's what I want to ask you, though, before we get to the law, on the facts. Isn't it possible that even the Trump administration, or more likely, of course, the politicos who are running the Bureau of Alcohol, Tobacco, and Firearms. They saw what happened in Vegas, and maybe they said we were wrong. We just had the worst mass murder in American history. Maybe we should have outlawed these bump stocks. How can it be a negative for the validity of the regulation to say, all right, we looked at the world and decided this is a better way to do it? That just drives me crazy. I don't understand it.
Yeah. So I agree with you, and let me give, just like you've done for me, the opposite, the strong argument on the opposite. I think, which is to say, if you think that the expert agency that is charged with implementing these regulations has already consistently taken a position after looking at this, that the statute means one thing and you can't read it to mean this other thing, a consistent line of those across administrations, I think, is some evidence that maybe the statute can't bear that kind of meaning. What I think you're getting at in the strong version of that argument is, and the interpretation of the statute shouldn't change just because something happens out in the world, like a terrible mass shooting. What I think you're getting at, though, is that what the mass shooting did was not cause, or at least the strong version of the argument on their side is, it didn't cause them to change the reading of the statute. It just caused them to take a closer look than they had looked in previous cases. I didn't follow this really closely, but I think that most of the determinations in prior administrations were made through individualized determinations about individual devices, not like this one was done through notice and comment rulemaking, like the formalized process where they go back and look at this in more official ways. And so I agree. I think it's fair for the agency to say, look, something major happened. It's okay for us to take a closer look at this than we have in the past when we just looked at this on like a device by device kind of topic.
So that really thoughtful response what triggers so much in me, because I'm sorry, I can't resist. What I want to say, the baseline assumption of your response, which I think was somewhat devil's advocate, was, and the devil is ably represented here, is there's a meaning to these words, but intrinsically. But this is more a con law point I want to make, and this was not a con law case. Somehow, and I'm going to say it, I'm just going to call him out. Somehow, Larry Solomon, and you can distance yourself from all of this. Somehow, Larry Solomon and Randy Barnett and others have convinced other people that imprecise language, whether in a statute or a constitution, has a determinate fixed meaning as applied to events that haven't happened yet. And yes, we know what 35 means without diagnosing the individual. We know what 2 senators means without diagnosing what that means. But we don't know what other words mean, like equal protection, due process, free exercise, freedom of speech. They have no intrinsic meaning as applied to facts we don't know about yet. And the same is true for federal statutes. And that's what Posner said in Bostock. Posner said, because of sex doesn't have an intrinsic meaning, it has a meaning in context of everything. And they knew that when they wrote it. That's why I think your devil's advocate argument, I think, falls a little short, because it just doesn't. Yeah. It's not real life. These words don't have.
I think I will agree with you that, and now taking off my devil's advocate hat. Yes. That lots of things, especially in the Constitution, but also in the statutes, have a range of meanings that are acceptable, reasonable readings, and not like a single determinate reading, which. Yes. You know, as we know, that there's a variety of originalist responses to that, and some of them accept that there's a range of possible meanings. But yeah, I think that's exactly right. There's a range of reasonable meanings, but I wouldn't go so far as to say. I personally wouldn't go so far as to say that there's no determinate meaning. There's some range of plausible readings. Some readings are non-plausible.
So 2 things about that last point, and we're off the rails now, but it's good. It's a good conversation. On that last point, you said that because I'm attacked with this point all the time. There's a range of determinate meanings, to which I always respond, and I have maybe you'll have one. I have never heard a legitimate response to this. Is no one is saying in the bump stock case from last week, the court could say, and by the way, Trump is president, or the other way, by the way. It is now a capital offense to own a gun in the state of New York. No one is saying that.
Yeah.
I've never said that. No one smart has ever said that. What we say is in most, if not all, litigated cases where we've gotten to the Supreme Court, or at least an appellate court, there's going to be a range of acceptable meanings. Applying that, though, specifically to the bump stock case, the question is, so Congress passes this law that has a range of meanings. Who gets to decide within reason on the acceptable range of meanings? Bureau of Alcohol, Tobacco, and Firearms, whose job it is to do it, or the Supreme Court or federal judges? And now, if it's an irrational reading, that's different. But if it's a rational reading, do you think the interpretation by the Bureau of Alcohol, Tobacco, and Firearms of the statute prohibiting firearms and other things, by the way, machine guns and other things, was it a rational reading?
I think so.
Yeah.
I think I kind of disagree with both the majority and the dissent, because the majority says it's clear it can only mean only exclude bump stocks, and the dissent says it's clear that it has to include bump stocks. I think they're both reasonable readings of the statute.
Me too.
And so I agree that in that case, if ATF is implementing a reasonable reading of the statute, then they should be the ones that are allowed to regulate or allowed to, give their interpretation of the statute, because they're the experts who the statute empowers to issue regulations that are interpreting the statute.
Is there any world where the Congress, so for the audience out there, this was a statutory interpretation question, which means Congress can change it. Now, there may be Second Amendment issues when or if they do that, but this case, reversed is the wrong word. The result here can be reversed by Congress. There's no question about that. And then someone would bring a Second Amendment challenge probably to the prohibition on bump stocks. Is there a world where Congress actually gets in the game and passes a prohibition on bump stocks?
So one point on what you said, which is Justice Alito's concurrence in the bump stock case, says essentially, look, the 1934 Congress that enacted this law, they probably wouldn't have seen any difference between a machine gun and a rifle equipped with bump stock. But the words can only mean one thing, and they can't mean bump stocks. But Congress should act, right? So I think he's wrong that it can only mean one thing, but it also is just like, I think demonstrates how far textualism has seeped into the bones of Supreme Court textual interpretation, that it's not even like a possibility that we would read the statute in light of the purposes that are pretty uncontroversial, that they wanted to ban these types of devices. And then the call to Congress to do something about it is just blind to the realities that we have a non-functional Congress right now. I don't know. I would hope that they would do something about it. I saw that there was that the Democrats had introduced a proposal to do something, and that the Republicans were blocking it. So I don't know. I hope that's not where it's going to end, but that looks like where we're at so far.
Jake, I have never, ever held myself out as a gun expert. I am a Second Amendment expert. I would hold myself off on that, but I'm not. The technology of guns is not something I would ever hold myself at. So I guess I do have a question. If this case had come out the other way, so now bump stocks are effectively taken off the market, would have been the response. How long would it have been till somebody invented something else that could make semi-automatic weapons function more like a rifle? Like, would it have really taken a very long time?
So I also don't hold myself out as a firearms expert. But so the statute includes any devices that will convert a weapon.
I know. How'd they get around that?
It's supposed to cover them. Yes.
How'd they get around
that? The majority focused on the internal functioning of the weapon, and the bump stock doesn't change the internal functioning. So it doesn't convert it to an automatic weapon in the majority's reading, because it doesn't change the internal functioning. So if the court had upheld the rule, I think that I think it would have been hard to make devices that would have done the same thing without running afoul of the prohibition on the machine guns and the devices that convert a weapon to a machine gun.
Okay.
That said, there are non-technological ways to do this, like the majority, both the majority and the dissent acknowledge, like with zip ties and belt buckles. But of course, people aren't committing mass shootings like by bump stocking a rifle from their belt buckle.
Okay. A couple more gun questions. So now there are 5 Jake Charleses on the Supreme Court, which I actually would be very happy about.
I
If
think
that were to
you're
happen. You're not running? If nominated, you will not serve. If elected, okay. Judge Posner said that. Posner once said to me, I got to introduce Posner once. He actually said to the Daily Beast, "I've never wanted to be on the Supreme Court because it's not a real court." He really said that. He was doing that. He was doing that out of friendship, but he did do it anyway.
Yeah.
Although he didn't believe that, but he almost believed it. The difference between us was negligible and had no relevance to the real world anyway. Okay, so there's 5 Jake Charleses on the Supreme Court, and I won't go back to Heller. And a city like DC or Chicago or Atlanta or state bans all handguns. So now we really have a law that is, very few states had it, or no states, I don't think, banned all handguns at the time. Cities did, but I don't think states did. What does Justice Charles do if that law, what I'm really asking, of course, is what is Justice Charles's position on the Second Amendment left to his own devices?
Yeah, it's weird because I've been writing on the Second Amendment for half a decade, and I still think
but Jake, you've done a decade's worth of work in that half a decade. So go ahead.
I have been lucky. I still think it's a really hard. It's really hard for me. Still, both looking at kind of the original materials and thinking about constitutional interpretation and application today, because if I think, well, would the founding generation have been okay with, widespread gun confiscation? I think clearly the answer is no to that. But the context in which they had their fears was the fears of a tyrannical federal government, and coming off of a monarchical government, and tyranny was what they were concerned about. Some people still are concerned about tyranny today coming from the federal government. I personally am not fearful of a tyrannical federal government. I think we have lots of checks and balances. I think many countries in the world show that you can have checks on tyrannical government without shooting down the people in leadership positions. And so I don't think it's necessary to that goal. But if you're thinking about, well, let me just answer on 2 levels. One, I think reading the materials that the founding generation connected, reading the materials and the text of the Second Amendment, that the militia was connected to what the right was for, and that limits in some ways what the protection provides for. I don't know exactly how, but it limits somehow. If you're answering it in terms of like an unenumerated right, like a substantive
pause on that. So the first.
So maybe just do first, Second Amendment first.
Yeah,
okay.
For the first thing you said, I want to be clear for the audience because you really are an expert on this. It is your considered view that there's some military oomph to the Second Amendment, that the militia oomph that the court has, Justice Scalia discarded in Heller.
Yes.
Your second, okay. Now we're moving now. With Sandy Levinson, who we all, I think, respect, liberal, conservative, moderate, I don't care. If you don't respect Sandy Levinson, then I don't want to talk to you. What Sandy has said, and Akhil Lamar too, I think, if I had this right, is no, the Second Amendment wasn't about this. That's absurd. It was about militias and all the stuff you said in the first part. But if one believes in unenumerated rights, and virtually everybody in America does, because there's nothing in America about raising your kids, in the Constitution, about raising your kids, and the court has said you have a constitutional right to raise your kids the way you see fit, if you're competent, and 10 other unenumerated rights I could talk about. What Sandy would say is, if we have unenumerated rights, Siegel doesn't want that, but most people do, the right to own a gun has to be one of them in America because of our fascination with guns. I've got to say, I have sympathy for that argument.
Yeah, and I think so. Sandy wrote this really interesting article called "The Embarrassing Second Amendment" in 1989.
Yes.
That sort of
started
really helped. Yeah, give credence to arguments for the Second Amendment, and he based that on Republican political theory about this anti-tyranny rationale. So I think even though he was talking about it in terms of an individual right, he was still connecting it to these anti-tyranny type concerns. In terms of the unenumerated, I also have sympathy for that. I think my truest views, which I've never said on a recording before,
Excellent. Excellent.
are probably something that's kind of like the opposite of Justice Stevens' dissent in McDonald, which was analyzing it under a substantive due process and thinking about a right to a gun. And I think I agree with you that probably looking at our history and tradition, there probably is some sort of right that's deeply rooted in our history and tradition for private gun ownership.
Yeah.
That doesn't answer the question of like, what does it mean? What authority does a state or federal government have with respect to that? But I think it does mean that there's a right, at issue. And so there's not kind of carte blanche to regulate in the same way that there's, carte blanche to regulate any other kind of area that doesn't regulate something that's implicated in a fundamental value.
And that's really what's so interesting, I guess. I'm now talking without having thought through what I'm about to say, which I hope is okay for a podcast. I hope it's okay. Most constitutional rights don't come with a downside. Voting doesn't come with a downside. I mean, some people would argue, but most people accept. To the extent there's an unenumerated right to vote, it is unenumerated in this country. It's just, there are very few downsides to it. And the right to self-defense, not the right to own a gun, the right to self-defense, which is different, doesn't really have a downside. If someone's attacking you and you're really in peril, you have a right to defend yourself. That's just a right that we all have. I think the right to raise your kids. Obviously, if you're an abusive parent, it has a cost. But abusive parents don't have a right to raise their kids. Only parents who are following the law have a right to raise their kids. But guns are different. There is such a cost. There's a cost to free speech, no question. Libels, but it's not life and death. Are we okay to say guns are different? Like if there is an unenumerated right to have guns in America for private purposes, so we're not in the Second Amendment world, it has to be a different kind of fundamental right because it has a cost that other fundamental rights don't have. It's a direct cost as opposed to a cost twice removed.
Yeah, I feel partly sympathetic to this argument, except for that I have trouble with the line drawing because I think the criminal procedure protections also have potential costs, right? And maybe you want to say those are one step removed. I'm not sure that's enough of a difference in kind as a difference in degree. Like if we're excluding someone's confession, like because of what the police did, and then they might victimize other people. Like that's something like a direct cost as a result of vindicating a fundamental right.
100%.
Hate speech, maybe not like life and death matters, but it can have real deep harm to people.
Yeah, that's a fair
protesting at a funeral with terrible messages about someone's loved one also can have real direct costs. But yes, I mean, I think you might not be able to distinguish it based on the kind of harm, but maybe the magnitude of the harm that's happening. Daryl Miller has a really great paper called Second Amendment Equilibria and talks about how if we're thinking about rights and regulation, we have to think about them in some sort of like equilibrium type relationship in the way that they thought about it in the founding generation. And so as the harms from the exercise of the right increase, then we have to allow regulatory authority to increase also to maintain that initial balance. Like if they're setting the balance, like Justice Scalia said in Heller, between harms and rights, well, then we gotta keep that same balance going. And so as the harms increase, well, then the regulatory authority also has to increase.
As the harms increase, the regulatory authority has to increase. That is simply a great answer. Okay. We're going to leave guns behind. We have a couple minutes left. One current event headline I want to ask you about, and I want to raise this again, Jay, because you're my 123rd guest with 3 repeats, including you. Most of those, when it's been, I've gone outside of academia, but when I'm in academia, most of those are more senior law professors than you. Most of them have been full professors chaired for a long time. Not all, and I've tried to get a lot of young people on here, obviously, and you're one of them. But you are relatively new to this world compared to me, 34 years. So Justice Thomas. So I believe this is fair, and if anyone listening, we're taping this on Thursday at 2:00 p.m. If anyone listening to this when it comes out, I hope tonight or tomorrow morning before the 10 o'clock rush, listening to this disagrees with this, please contact me. Please. I think it is undisputed that what I'm about to say. I don't believe Justice Thomas or anyone has disputed that Harlan Crow has done the following things for Justice Thomas. He helped pay for his mother's house. He bought his mother's house and then let her live there rent-free, I believe. But whatever it is, he gave ample financial support for his mother's house. He gave at least $50,000 to his wife's business. I think there's more, but we know for a fact there's at least one $50,000 gift to Ginny Thomas's business. So we have mother's house, wife's business. He definitely paid for the kids' tuition at not his naturally born, but I forget the right word, but not his genetic son, but a fourth nephew or something who he took in and raised. That son, enormous amount of money for his private school tuition, luxury vacations, and a museum in Justice Thomas's hometown devoted to Justice Thomas. All five of those things are undisputed. Okay. So my reaction to that is I don't understand how anybody can look at that and not go, I don't care what your political persuasion is, that has to be wrong. This is $4 million at least over a period of years. He did not know Justice Thomas before he got to the court. That's been admitted. And no one is taking issue with those facts, as far as I can tell. There are other disputed gifts, but not those. Are you outraged by this?
Yes, I think that anybody who's looking at the court and either if you're a person who wants the court to have respect and trust of the American people, you should be the first in line to say that this is really problematic. And even if you're not, I think this should be really problematic. And I think I agree with you from what I've seen you tweeting about this, that the response seems to be something like, okay, well, what cases should he have recused from? Or what law did he break by doing this? And to me, those are asking too myopic questions about what's wrong here. And what's wrong here is that someone who has life tenure, who's a public official, who's one of 9 people that can make monumental decisions for the United States, is getting millions of dollars from someone who is, if not having business directly before the court on a regular basis, is someone who is clearly, as you said, fostering this relationship because of the fact that Justice Thomas is a justice of the Supreme Court and not for purely friendly reasons. I think there was like a quote from Harlan Crow in one of the ProPublica stories that asked him, would you be friends with him if he wasn't a justice? And he was like, that's a really good question. I'm not sure I can answer that. Right. Which is that's I think that's a dead giveaway, is that the relationship is fostered because of his status as a Supreme Court justice. And I think that's the part that's problematic.
So I want to be transparent with my audience. I asked Jake this question, not knowing, frankly, how we haven't discussed this really, not any meaningful way, not knowing what you would say, but I had an ulterior motive for asking you. So I think your answer is great, and I obviously agree with it. I didn't know that about Harlan Crow, actually. I didn't know he had said that. That's crazy, or allegedly said that, whatever. But I do, and this is not Jake Charles, this is Eric Siegel talking. I am despondent at the reaction of other law professors on this issue, and I don't understand it. This is all Eric, not Jake. Will Bowe joked about this on his podcast, apparently, and quipped Thomas is worth more than this or should have gotten more money. I don't know if Will was serious, but joking about this even without then saying, of course, I'm joking, this is the worst thing that's ever happened, is unconscionable to me. And it makes me want to cry and quit. It really does. Is there nothing we can, where it leads me to is, for most of my academic career, really all of it, until 2 years ago, I can always find common ground on almost any issue with people. And I try. This podcast was an effort originally to do that, to bring in conservatives and find common ground, or liberals I disagree with and find common ground. I don't believe any reasonable person can look at Justice Thomas's behavior here and say that's at least highly troubling and maybe even impeachable. I'm not taking a position on impeachable. I'm not asking you about that. But it is wildly troubling. But no one is saying that on the right. No one. Is there any way for you to talk me up? Because I swear, I'm ready to call it a day. if we can't agree on this, is there anything left to agree on? So you are young, a little bit idealistic, less jaded than I am. You're just starting out, although you've done an amazing, you've already had a great career, but you're just starting out. Can you make me feel better?
I don't know if I can.
Okay.
I don't know. With respect to the responses.
No, I'm not like that. Just the
Okay.
court in general. Just not the academic response.
So so here's where I'm a little bit heartened. I guess even with something like that, I think is egregious as this is that it is a matter of public consciousness now in a way that past things the court was doing may have bothered us or some set of the legal academy, but we're not penetrating into the public consciousness. I think now there's a spotlight on the Supreme Court and especially a greater tendency of journalists to treat Supreme Court justices as political actors. And so to do investigations and to figure out conversations or views they've expressed in other settings, that I think that's a good thing that we're now seeing. And so it's heartening to me that there's more public engagement about this question of like, maybe we should actually know something about the 9 people that have the most power in the US or among the most power in the US and not treat them as like the oracles that are up on the hill that we can't like look behind the curtains and see what's going on there. That doesn't mean that I think it's okay to like, surreptitiously record them or anything like that. But I do think that it's fair to do these kind of investigations on their finances or on the things that they're reporting or not reporting, on the views they're expressing in public and other settings. I totally think that's a fair thing. And I feel better about the fact that is getting more normalized than it has been in the past.
That's a great answer. And I want to be clear. I think we agree on this. I made one substantive comment about the Alito taping, but I didn't know they had taped his wife when I did that. And I deleted it as soon as I found out they taped his wife as well, and then said, I am not in favor of that kind of reporting.
Yeah.
I'm just not.
Right.
The secretly recording, maybe we can have a healthy debate about, but pretending to be someone you're not to elicit information, no, we don't.
Totally
That's
agree.
just not. Yeah, okay. Jake, so listen, audience, this guy's name is Jake Charles, and I am telling you, I get sent articles all the time to review. Yesterday I was sent 2 long ones for tenure purposes or other purposes at other schools. You are absolutely one of the best young scholars in America today. And whether you are liberal or conservative, I think you will find Jake fair. He has his priors, but you'll find him fair and balanced. And it's not, and the reason I've kind of tried to pay attention to you, the very specific reason is you do both things well. You wrote an incredibly scholarly law review article that was everything anybody wants a law review article to be. Maybe a little long, but that's the world we live in. But other than that, it was a perfect law review article. But you also can go on CNN or podcasts or whatever and be very accessible to the public. And those are 2 very different skills. And you're really good at both of them. Thank you for coming on again.
Thank
I really
you.
appreciate it. No, I really
Thanks
mean
so
it.
much.
And I'll be seeing you again. Thanks, Jake.
Good talking to you.